Good morning. I'm Joe Copeland. I'm going to be your teacher for the next 9 weeks. If you're viewing this video, you probably have already read the written version of it, which appears in our announcements for the first week. But I just wanted to follow up with a little video because this will be my habit from now on. Each week I'll post a video at the beginning of the week, possibly interim videos as well, but usually I only do one video a week. It won't be too long. It'll be less than 10 minutes long, sometimes a good bit less than that. This week will be short, I think. In that video, as you'll see, I'll discuss the topics that we're going to be covering in the coming week. This week, our first, is a very basic topic. We're going to talk about the structure of the federal court system. Some of you may have encountered the federal courts or some other court system, a state court system, in your experiences. Many of you probably have not. And so the language of the court system, the structure, the function, will be new to you, and that's fine. I don't expect you to know it already. That's what we're here for, to learn. But this week, although in subsequent weeks we're going to be dealing with state courts as well, this week we're concentrating on the federal courts. You have some readings that describe those courts and that system to you. The readings will tell you that there are many subordinate, let's call it subordinate, federal trial courts, specialty courts like the bankruptcy court or the veterans courts or the maritime courts. We don't really deal with those in this case. This is a basic class to help you understand the structure of a court system, and we start with the federal. As I said in the written announcement, it helps to visualize the court system as a pyramid. That's not a pyramid, it's a, V. But I only have two hands. The base of that pyramid is composed of the trial level courts. In any court system, you have an initial trial level, a level at which the case, whether it's a criminal case or a civil case, is first brought to the attention of a court. At a trial, the facts of the case, the evidence, the testimony, the allegations of each party are brought before a judge and possibly a jury, usually a jury. The jury, in conjunction with the judge and the judge's instructions, will determine what are the true facts of the case, and they will render a verdict. That verdict will be dissatisfactory, let's say, to one of the parties, maybe both, but certainly one. In other words, one side will lose, one side will win, if we look at this as a game. And when that happens, the losing side, the party that isn't satisfied with the outcome of the case, has the option of asking another court called an appeals court to review, review the trial court's decision. And not to try it again, not to bring in new evidence, not to hear the facts again, the testimony, etc., but simply to determine whether the trial court, the trial judge really, made any mistakes of law during the trial that led to an erroneous conclusion. That's what an appeals court does. So you have a trial, and you have, in the federal system, an intermediate appeal to a level called the U.S. Courts of Appeal. You'll be studying this and commenting on it in your discussion boards and in your short paper. In the federal system, that's usually the end of the road. Now, we all know that above the courts of appeal is the U.S. Supreme Court, which is the highest court in the land. However, it's also the only court that gets to determine its own docket. That is to say, what that means is that the U.S. Supreme Court can accept or reject cases at will. They don't have to take any cases. They take the cases that they feel are the most legally significant at the time. They take cases that represent a conflict among the courts of appeal across the country. They take cases that they want to take. So very often, when you've been involved in a U.S. District Court trial and then in an appeal to the Court of Appeals, you may, if you have the time and the money, you may try to have your case heard by the U.S. Supreme Court. The chances are really good that the court will not hear your case. They accept only a teensy little percentage of the cases that are brought to them through a vehicle called the writ of certiorari. You will learn about that this week and in subsequent weeks as well. We'll discuss it later. I won't bring that in right now because I'm getting ahead of ourselves a little. You will also see that even though you might have a really good case, a really interesting, a really significant case that you want to bring to the attention of the U.S. Supreme Court, you might not have the money to do it. It's a very expensive and a very lengthy process, and we'll talk about that a little as we go along. We'll get to discuss whether that is a that burden of time and money is an indication that perhaps we get results that are less than just in our federal court system. I don't know whether we do or not. It seems to work out fairly well in most cases, but we all are aware of some cases where the outcome has not seemed to be very fair, has not seemed to be very just, and the results of that outcome have been developments in our society that perhaps we don't like. That's what happens in a democracy. Whether we like it or not, sometimes the side that we're on doesn't win. Same thing happens in a court system. I'm going to stop talking about that right now because I'm getting off topic, but what I'm looking forward to this week is getting to know you through your discussion board posts, not only the Getting Acquainted discussion board, which I'm already weighing in on a little bit, but also the topical one, the one that has to do with whether you think federal judges should be appointed or elected. Please understand that they are appointed right now by the president, and they are vetted, they are investigated by the Senate Judiciary Committee, and then either approved or disapproved. As you probably know, we have a controversy going on right now about a potential nominee for the U.S. Supreme Court after the death of Justice Scalia. We'll get into that as the term goes on. We may even see a resolution of it, although I wouldn't hold my breath if I were you. Let me just say goodbye. At this point, I'm already at 8 minutes, which is a little longer than I usually like to make these. I understand your time is valuable. You don't have time to sit around watching an old lady talking to a camera, so we will discuss this in writing as the week goes on. I really look forward to getting to know all of you. Please know that the best way to get in touch with me quickly and to get a quick response is to send me an email. I have my phone, just like all of you probably do, I have my phone programmed for the SNHU emails to come right through and ping, and I'll answer them unless I'm driving or otherwise unable to do it. I will answer you right away. So, bye, and I'll see you each week, and hope you enjoy this class.